But I have submissions on two issues only. One was what Mr. Nafde was advocating just now regarding demolition of a state into union territory. And the only thing I wish to add on what he said was, if Lordship would just have a look at 246(4).
Is it way?
Which matter are you appearing, Mr. Diwedi?
Correct number दे दो इनका.
In the first matter, we filed a petition, but we were told to file a intervention application, and then an order was passed on that we will be heard like any other petitioner.
So you are for an intervener?
Yes.
Which just give us just a reference so that we can, just for the sake of the record, we need to complete the record.
Lord, it is writ petition number. It is IA number 145.
IA number
2.
Sorry, can you come again, please?
IA number 145.
Yes.
852.
Yes.
-53 of 2019. This is in writ petition civil number 1013 of 2019.
Actually, I think forgot to add.
overruling, Lord, inevitably implies that the past practice, whether right or wrong, it will continue to operate and will not be affected by the judgment. But it accepts the fact that if the declaration is made of invalidity of the impugned amendments, then that may have a consequence, and therefore lordships prospectively overrule it. So implicit in this prospective overruling is the invalidity of those supposed invalidity, and therefore lordships try to save it. Now, Lord, another way of looking at it is, Lord, look at it this way. Supposing lordships accept my viewpoint on the basis of the text and the context, and lordships come to the conclusion that yes, there is a case for this, that the power is not available, and therefore the impugned COs are invalid. Now, in order to prevent the effect from traversing on to the earlier ones, your lordship would pass whatever relief lordships can mold under 142, lordship would do that. But that doesn't mean, Lord, that on the basis of this past, continued exercise of power, your lordships would ignore the text and the context. If the text and the context, as per my submission, inevitably show that yes, the power could not have survived beyond 57, then perhaps, Lord, there is a case to look into it.
All right. Now, Mr. Dwivedi, should we start with the first point? Because first you have to add on to what has been argued by Mr. So maybe just because we are at about 3:35, so you can maybe in 5 or 10 minutes conclude the first point.
What I wanted to add was, apart from what my friend had said, additionally, if your lordship would just have a look at 246(4). Lordships have had a look at it on several occasions, but then my friend perhaps omitted to see it. 246(4). Parliament has power to make laws with respect to any of the matter for any of the territory of India, which is union territory, not included in a state, notwithstanding that such matter is a matter enumerated in the state list. Now, that's the inevitable consequence of when you break down the state into a union territory, then Parliament is the sole legislature. Now, when Parliament becomes the sole legislature, Lord, then inevitably, Lord, the state comes out of the federal structure. Because lordships have said, Article 1, and my friends read some part of it, Lord, I can read some part of it too. Lord, Article 1 says India is a union of state and refers to Schedule 1. I feel lordship would just have Schedule 1 for a moment. Now, Schedule 1, Lord, specifies the states in Article 1 and 4. First schedule. It specifies the states, and Kashmir is there at item 15. And then, Lord, it goes on to have item 2. The lordship would have, Lord, 28 states. Then item 2, union territories. These are not specified as states. Now, though they are part of territory of India, as per Article 1, yet when it comes to federal structure, Lord, union territories are not part of that federal structure. This is, Lord, there are decisions I have referred to in my judgment, but the decision to that effect, Lord, that Article 1 does not contemplate union territory constituting part of federal structure. And for obvious reason, Lord, if your lordship would recall the definition of federal structure in our constitution given by Dr. Ambedkar, he said there has to be a dual polity. And that is how he declined the entire objections to the Constitution of India as being unitary and not being federal. Your lordship would recall,
now there is a nuance on that. Following the NCT judgment,
yes,
we have placed Delhi in a different.
And I was coming to that only. Lord, it goes further.
Position.
what your lordship has said goes further. What it says is that dual polity contemplates that citizen of every state is entitled to be governed by the laws made by two different legislatures. That's the concept of dual polity. Where for local issues, the right is for the local to get himself governed by the local legislature on local issues. And so far as the national issues or bigger issues are concerned, Parliament. That right gets defeated. And therefore, the dual polity gets lost as per Lordship's judgment. States are not appendages, as the Lordship said, not satellites of the Union. They are their own plenary selves created under the Constitution, not the Parliament. So this results in the demolition of the entire dual polity and therefore destruction of the federal structure. And no one can say, Lord, the Jammu and Kashmir did not satisfy the requirement of federal structure. Our federal structure is not defined, but there's an interesting aspect which I wanted to bring to your Lordship's notice in this regard. Lord, all throughout, we have been hearing about the quasi-federal character and so on and so forth. It's not truly federal as the American system in our constitution. But in each of these judgments which say so, what your Lordship would see is they omit to notice the Constitution of Jammu and Kashmir. And when we come to Constitution of Jammu and Kashmir, it goes one step ahead of any other constitution, and that is this. It is the Constitution of Jammu and Kashmir in our federal structure which lays down the parliamentary jurisdiction. It lays down the parliamentary jurisdiction under the commitment given by the framers of the Constitution and the Dominion of India. It lays down the tone and terror of the state and the union relations. Finally, that's what the framers have said. And then have a look at Section 5. Because if you don't accept this fact, Lord, then Section 5 becomes, which is the, according to me, the soul and heart of the JK Constitution. That gets absolutely demolished. That's the basic structure of the JK Constitution. And Section 5 says the power of state would be not on any subject which is given to the Parliament. Parliament has been given enumerated powers, that is entry 1 to 96 and not 97 and Article 248. So which means residuary entry is not there. Rest of the entries 1 to 96 are there with Parliament under the Constitution of JNK. The concurrent list and the state list are with the state, except to the extent, Lord, that correspond to the instrument of accession. Now, can you look at this, Lord? Here is a case where the state is going to decide what is the jurisdiction of Parliament and what is the center-state relations, scope of that. So that's the extent to which the autonomy was given to JNK, guaranteed autonomy. And to borrow Dr. Rajiv Dhawan's phrase, Lord, it is democratization of power in India in the shape of autonomy. He referred to various provisions, various levels of autonomy was given. Now, here is a case where the level of autonomy is stupendously raised. But nevertheless, it is part of federal structure. We can't deny because Article 1 and the schedules say so. But by reducing that state into a union territory, what we are doing is we are bringing it under 246(4), where the people of the state, both the union territories now will have only one legislature, both for local and the national issues. The right to be governed under a dual polity goes for a toss. And that is how we'll have to see Section 3, Article 3, I'm sorry. Berubari gives a clear indication. I'll show that passage. But that is how we'll have to see. The power is limited. We can't, the amendments that have come is only for a specific object. And the object amendment by adding the explanations to Article 3. They have come for a specific object of overruling the Berubari case, to the extent it said that union territory is not governed by. So to that extent they overrule. But the remaining part of Berubari judgment, which says that states cannot be, they don't have a territorial integrity, the word used. But then they cannot be, they can be addition to the state, they can be subtraction from the state by giving it to another state. That way, what you are conferring is the dual polity. Whenever you change the territory of the state, you are retaining the dual polity for the citizens. Because from this state, they go to another state where the dual polity continues. But then by demolishing it, what we are doing is reducing and demolishing the dual polity into a unitary system under 246(4). That is what I wanted to add to my friends. And I have in my written submissions, given the host of cases where lordships have said this federal structure cannot be disturbed. This is my written submissions, and this is, I would request lordships to see page 44 and 45 in that regard. 44, 45. This is at page, as my friend correctly noted, I have given the internal page, page 40, PDF page, no.
The written submission body.
What is the PDF page?
394.
The internal page is 44 and 45. So therefore, I submit with respect, Article 1 completely excludes union territories, and therefore, once you reduce the state into a union territory, you deprive me of my right to be governed by two legislatures. That's the crux of the dual polity. Internal page 44 would be at page 437 of the PDF.
437.
437. And I'm only referring to page 44 to 46, and I've referred to a host of judgments, which lordships are clearly aware of. No? But basically, referring to two last judgments, if lordship would see, at page 46, internal page 46, two last judgments, no? Of which one of the Chief Justice was a partner, 2017-12 SCC 1, this is general, and then 2018 volume 8 SCC 501, and I have given the paragraphs too.
2018
volume 8 SCC 501, and I've given the paragraphs also in the PDF.
there. Yes.
And then there is another page lordship may have, no? 46 and 47, internal page.
Yes.
That is what I wish to add. No? Now, before I proceed, Lord, there were two issues which were rankling in lordship's mind, Lord, from the very beginning, first day. One was, in fact, two from her lordships, and one from Lord Justice Khanna. Lordship had an issue with regard to sovereignty, and the observation was that once you accede to the dominion of India, you surrender all your sovereignty. Now, lots of things have been, I'm already informed you, just that instrument of accession would not amount to surrender unless there is a merger agreement which says that you merge your sovereignty, as happened in the case of other states, which I will show. The other states had not only not acceded before 15th of August 47, they had signed as a precondition made by the Dominion of India that they will sign the standstill agreement also, which covers the matters of local concern. And after that, Lord, they acceded to the Union of India. Thereafter, Lord, they further, when they merged with the adjoining states, the adjoining provinces automatically merged, provinces under the Government of India Act, they automatically merged. Indian states merged primarily with the provinces, or they formed their own federation. Then they were directly administered states also. They all signed the merger agreements with the Dominion of India, conceding all their powers of legislation. And that is why, Your Lordship would see, Article 238 was incorporated. Article 238, Lord, expressly applied Part 6 and 7. And of course, consequently, Part 11, which is 245, 246, 254, and so on and so forth, to all the other Indian states. But when it came to Jammu and Kashmir, Lordship would have noticed that in 370, clause 1, to 38 is excluded. This is despite the fact, Lord, what is important is this is despite the fact that the Kashmir was placed as a Part B state in the schedule, that point of time when the constitution was enacted.
Now the new point.